From same-sex marriage to the Rahul Gandhi disqualification, the courts have been at the center of our news headlines this past week. I'm Barkha Dutt. You're with the Mojo Story. Is India standing on the cusp of history when it comes to legalizing same-sex marriage? A battalion of lawyers, including senior advocate Abhishek Singhvi, has been at the forefront of arguing that it is time to do this, framed within the rights to equality and other fundamental rights already granted in the Indian Constitution. Abhishek Singhvi will be joining us in moments from now. It's been a busy week for the eminent lawyer and jurist. Apart from arguing in favor of legalizing same-sex marriage, Rahul Gandhi has continued to be in the headlines. A Surat court where the Congress had appealed, Abhishek Singhvi is Rahul Gandhi's lawyer, has rejected Mr. Gandhi's appeal in a defamation case which has convicted him with a 2-year sentence, finding him guilty for slurring the Modi surname. Remember, Rahul Gandhi, in a rhetorical speech, had talked about the links between corruption and the Modi surname. The court has found him guilty of defamation. Even as all of this is happening, there is reports of churn in Maharashtra, rumors of Sharad Pawar walking out of the alliance with the Congress and the Uddhav Thackeray Shiv Sena, even as the Supreme Court verdict is awaited in this case, where too Abhishek Singhvi is the man of the moment. So there's a lot to talk about with our newsmaker today. Let's bring up Abhishek Singhvi. As I said, the courts have been at the epicenter of the news, and Abhishek Singhvi has been at the epicenter of all of these cases. So let me actually start with Rahul Gandhi first. We'll come to same-sex marriage. There's a lot of complex things to talk about that. How disappointed are you? Can we switch to Rahul Gandhi now? How disappointed are you, Abhishek Singhvi, with the verdict that you have got in the Rahul Gandhi case, Abhishek?
Thank you, Barkha. Just step back for a second, Barkha. Today, at the highest, Rahul Gandhi has been convicted for defamation by a magistrate, and his appeal on the merits of whether he committed defamation or not, a separate issue, is pending in the Sessions Court. The question is very short, but also seemingly ridiculous. While your appeal is pending on a conviction of defamation, should you be granted a stay of conviction so as not to disqualify? Now remember, Rahul Gandhi is not charged with corruption. Rahul Gandhi is not charged with murder. Obviously, he is not convicted of these two. Why is this provision made for stay of conviction? Obviously, because pending a first appeal decision on your main matter, you should not lose your parliamentary seat. Secondly, do you remember that Navjot Sidhu got this stay of conviction and therefore stay of disqualification when he was accused of what, Barkha? Murder. Do you know that 5 cases cited by the learned judge in the judgment 2-3 days ago, many of them are convictions of Prevention of Corruption Act, where you have got stay of conviction. You're not giving, apart from the fact, of course, that Rahul Gandhi ought never to have been convicted for 2 years. That's a separate issue. I'm not arguing that at the moment. Will you not give a stay of conviction of a defamation offense? Then why, what is the value that you are giving, countervailing value, to representing people, to being in parliament, to raising a voice in parliament, to raising public interest? So therefore, I think both the judgments are wrong. They are, of course, respected judgments because we respect the court and judicial system, which is why a hierarchy of appellate recourse is given. We'll be there shortly in the High Court, and we believe we have a strong case. We are confident of a positive result on a strong case, and we are going to be doing that shortly.
Why have you not been able to convince the court in Surat? You said you respect the judicial process. You're saying the court verdict is flawed. You've not been able to convince two consecutive courts now.
That's why, first of all, we have multiple hierarchies of appeal, precisely to correct errors. Secondly, on the face of it, let me leave it to you and your viewers to judge the errors of the judgment. And I'm not arguing law. I don't want to be technical. I don't want to anticipate my own arguments in the High Court. But kindly consider just these 3 facets. Is it wrong or right? And the fact that you've lost is no proof of correctness of the judgment. As they say, that an error perpetuated more than 3 times remains an error. That's why the Supreme Court is there to correct even a High Court error. But look at this. First 6 pages of the judgment of the Sessions Court are endless quotations from 6-7 judgments. You open up the page and you'll see it. Each of those cases he's quoted, he has underlined the relevant portion. All the relevant portions make out Rahul Gandhi's case by contrast. Because the relevant portion says if the charge is very serious, and one was a murder charge, then it says very serious prevention of corruption charge. Then you should be hesitant to give stay of conviction. Rahul Gandhi is asking for a stay of conviction of a defamation charge. Second error, repeatedly it seems to be unduly influenced by the fact that the person involved is as high a person as Prime Minister Modi because he says at three places Prime Minister Modi, Narendra Modi, along with 13 crore other Modis. By the way, I didn't know that one tenth of India's population is Modis, but it appears from the judgment it is. Now, the interesting part is that uh, it goes past the judge that Prime Minister Modi is not the complainant. He's not the complainant. Thirdly, he has given no weight to the very strong jurisdictional argument, or rather the lack of jurisdictional argument, for a Kolar incident filed in Surat, which lawyers call a 202 jurisdictional threshold objection. The magistrate has hardly considered it, and the Sessions Court does not consider the fact that the magistrate has not considered it. These are only 3 out of 10, 20 errors. So this is the way you challenge verdicts, and this is the way you hope to succeed because it's a highly infirm, erroneous, and unsustainable verdict.
Okay, lawyers partial to the BJP argue that it is mystifying that the Congress has not yet approached the Supreme Court to at least ask for a clubbing of the multiple petitions that are, in a sense, confronting Rahul Gandhi. Let me refer you to a Patna court that has issued summons, where in fact it is Sushil Modi, who is an OBC leader himself of the BJP, who is the aggrieved party, and there he is saying, I'm offended by Rahul Gandhi's remarks as an OBC member of my community. Why, out of curiosity, have you not approached the court for a clubbing of these cases, Mr.
There is a third BJP Modi in Ranchi, by the way, for your information. This is number two is Patna. There's a third BJP Modi complaint in Ranchi courts also. Now, Barkha, I mean, we are really touched by the unsolicited advice and care and concern shown by BJP lawyers about our case, and also about people making all kinds of statements that I would have drafted an appeal in 8 hours, I would have drafted an appeal in 24 hours. I'm quite amused to hear them. But that apart, those are cases at different stages. Those are cases at very nascent stages, or middle stages, or early stages. We, of course, reserve our right to do all that, all the clubbing, all the consolidation petitions. The real issue at the moment is to deal with a exclusion of Rahul Gandhi from Parliament. At the moment, perhaps we have some breathing time because the next session is not till monsoon session. But even then, it's very important that a voice as loud and as clear and as fearless as Rahul Gandhi's is not kept out of Parliament. That is why the suspension of conviction test was created. And to suggest that you must show some additional consequence before I give you a stay of conviction, which is, by the way, the fourth error in the judgment of the Sessions Court, is very strange because what more compelling reason can I give you that while my main appeal is pending, tomorrow I win my main appeal. Assume that I win my main appeal in the Sessions Court. Will you restore to me the 10 days I lost in the last session or the whole monsoon session which may have lost? So what is the balance of convenience? What is the irreversible prejudice? All of these factors are entirely in favor of Rahul Gandhi. So this is the priority, this is the concern. Clubbing and all can await their turn and will be resorted to according to law. We reserve all our rights in that respect.
Do you believe now that this case will travel all the way up to the Supreme Court? Is it your best
We
assessment
hope,
that
that it will travel up is undoubted. We hope the last leg of the travel will be by the BJP appeal,
what do you mean?
which means we win in the High Court. Which
And
is why
therefore the BJP would
appellant,
appeal against
therefore the
against
appellant would be the complainant, but otherwise we will appeal.
Okay.
We have
Let
full
me
faith in the system, and we believe that we are right, and we believe we have strong grounds.
you have framed a legal argument. Let me now ask you a political question. Many would believe that this is an election year. You have Karnataka, you have a bunch of assembly elections, you have the big general election coming up. Should Rahul Gandhi be wasting his time going from court to court, getting distracted in these legal arguments? I'm sure you have also bigger battles to fight. Many have asked, why doesn't he just say sorry? And I liken you at this point, him to Arvind Kejriwal. You would remember Mr. Kejriwal faced a slew of defamation cases, and he did All he did was apologize. That's one option. The other option could be to be disruptive and just say, you know what, I've done nothing wrong. I'll go to jail if need be.
Barkha,
Many people believe taking this route is actually costing you sympathy in the public eye. People are, going to get bored with the story. It's a
so
protracted
so
legal
let's
battle. It'll drag on. Why not just say sorry or then opt for jail?
so let's start one by one. But let's start before the one by one with the Panchtantra tale. The father and the son will walk, and you'll blame the donkey. The father will sit, and the son will walk. You'll blame the father. If the son sits, then you'll blame the father, etc., etc. You know the Panchtantra tale. There is no end to it. Take the first example. Why shouldn't Rahul Gandhi just not go to jail? Let me, by the way, tell you that Rahul Gandhi is one person who's not scared of jail. There have been occasions I am not at liberty to reveal when we've had to prevent him very forcefully, and I personally, from not opting to go to jail.
You mean
So
he
it's not
wanted
that.
to? You mean
Yes,
he
he was
wanted to?
ready. Not in this case. I'm saying generally, he
Hmm.
doesn't bother about that. But what we are concerned about is not the question of jail. It's the question of disqualification, which means that you have silenced his voice in the public space of parliament, legislature, an organ, a pillar of Indian democracy for 8 long years. This is the most ridiculous thing anybody is suggesting. That's your option one given to you by the Panchtantra tailwalas. The second option given to you is that he should simply say sorry.
Yeah.
Have you seen the kind of gloating going on for a one and a half sentence in a three-page speech taken out of context for which he has been convicted for defamation? Have you seen the gloating going on that respect? And imagine what will happen if he apologizes. He has done no wrong. I don't think he has committed defamation at all. Without committing defamation on a conviction, he's being lampooned on diverse ways on unsustainable grounds. The very same people you are saying, the moment he apologizes for something he doesn't believe in, he doesn't has not done, would face similar lampooning. Third, Rahul Gandhi is not the kind of person, and I'm certainly not the kind of person to advise him to be the kind of person he is not, to apologize for something he strongly believes he has not done. He has said something which, by no stretch of defamation, can be criminal defamation. The names he has taken are not complainants. Fake complaints have been set up by political opponents sprouting around the country with the Modi surname.
Well, Lalit
He
Modi
could,
has threatened to sue him.
yes, yes, of course. So, as I said, 13 crore Modis will all be able to sustain a criminal defamation. Why advise me to go and club from the Supreme Court? I can't club 13 crore cases.
Let me ask you this. Is it time to revisit the Supreme Court judgment in the Lily Thomas case? And I take you back to the ordinance that Rahul Gandhi, your government, wanted to introduce and Rahul Gandhi had opposed, which at that time was seen to be a kind of protection mechanism for Lalu Prasad Yadav, who'd been convicted in a corruption case. There are other lawyers who argued it's time to question the Supreme Court, to ask the Supreme Court to review its judgment, which enables this sort of automatic disqualification.
Actually, Rahul Gandhi is a much maligned and misunderstood person of this respect also. His act of opposition to the ordinance was not based on the issue involved now. I will agree with you openly and clearly that you need a one line amendment to the law saying that the one line, provided, however, that the disqualification shall kick in
Hmm.
after giving the person a chance to seek a stay of disqualification for at least 6 weeks or 8 weeks. That's all that you need. Rahul Gandhi's opposition was not to that, although that provision would also have been there in that ordinance. His opposition was to the concept of not disqualifying persons at all, despite conviction, endlessly. So, therefore, his opposition in its own place was valid. But I agree with you entirely that it needs a one line amendment because today we are out of power, tomorrow you will be in power, third day somebody else will be in power. It is not fair that yesterday Barkha Dutt is convicted and theoretically today, in Rahul Gandhi's case, it happened in 48 hours. In some BJP MLAs and MPs cases, it hasn't happened for weeks. Tomorrow, day after, you're disqualified, which you're entitled to do. I'm not saying you're not entitled to do because there is no space. Now, those who think that you can just parachute into a court and argue without papers, without filing appeals, without proper translations, in 2 days get a stay, that is a wrong approach. So, therefore, I agree with you that that amendment should be there.
So no clubbing of petitions, no apology, no going to jail. You're going to follow this through
No, I
legally.
didn't say no clubbing. Clubbing will be there in good time, but there is no immediate priority or urgency for that.
What is the timeline you're hopeful of getting relief for Rahul Gandhi in?
No, the matter will be filed shortly this coming week and be then listed shortly after that. Thereafter, the courts take over. Some inherent delays in court, but I would not imagine more than a few weeks either way because there is a process, unfortunately, or fortunately, natural justice has to be obeyed. You have to issue notice, people come and take time. But I don't think these timelines uh, should not at least be very long, and we should be cognizant of the fact that you may be irreversibly, irreparably, and unjustly excluding a person from the next session, which certainly would be gross injustice.
Okay, let's shift gear to the other big story of this week, which is the petitions that the Supreme Court is hearing on same-sex marriage and legalizing it. You're arguing in favor of this happening, and I thank you for that because I think all right-thinking people must be on that side of the argument. But the government has argued that this is A, urban and elitist. The demand is urban and elitist. B, it doesn't belong to the domain of the courts. It belongs to the domain of the legislature. How do you respond to these two arguments made by the center, Abhishek Singhvi?
Well, you may discount everything I say because I, as you have said, am appearing for a particular cause. Number one, caveat. Number two, I am very careful. I'm a little traditional about this. The matter is going on. I finish my arguments, but I don't want to prejudge matters in a sub judice sense at all. The court will take care of it. I can only give you either a factual response or the grounds or the contentions I raised. What will happen, what the judge will do, is for the bench to decide. Three things, Barkha. One is, I have never yet, and you can credit me with some experience of the courts, rarely if ever seen the kind of desperate attempt, not once but repeatedly, 5, 6 times by the government, repeatedly, to defer the matter, to prolong the matter, to adjourn the matter, to put it in cold storage. Now, your press has reported it. I don't want to get into details, but the intensity, the degree, the focus, the orchestration of this attempt repeatedly by very, very senior law officers is something unheard of, unsustained. Indeed, what you in the press have quoted as the court's response also was a little stern and strong precisely because the provocation was extreme. Second, this is a question of just turning around on the head the argument we are making to suggest that the legislature should be there. It's actually turning it on its head. Our first argument is, look, we are not touching personal law. Our second argument is, we are not asking you to rewrite anything. Our third, I'm obviously not elaborating, I'm giving you in bullets. Our third argument is very important. Take a particular act as it stands, called the SMA, Special Marriage Act. Don't rewrite a word of it. Do you do interpretation of existing words? Of course, you do it every day. You do it in hundreds of cases. In other cases like Vishaka, you do legislation also, but where there is no existing legislation. There was a vacuum. So you lay down the sexual harassment guidelines. We're not even asking for that. What we are saying is that in 5 or 6 places in the SMA, where the word is used as either wife, husband, or male, female, you have to simply use the word spouse or person. One. Two, we are saying, should you use it? Because of the larger constitutional backdrop, the overarching arc of Articles 14, 15, 16, 19, 21. What are they? Equality, non-discrimination. That's the heart of my case. Dignity, life and liberty, free speech and expression. What does non-discrimination mean in this case? The right to love, the right to be with a person of your choice, the right to live with that person is available equally to you and me. You are heterosexual, I am non-heterosexual. But you as a heterosexual have a right to convert it into marriage. I as a non-heterosexual cannot convert that right to love into marriage. This is clear discrimination. Now, does that sound anything about rewriting a law?
Yeah.
10 countries in the world have done it by interpretation. Other countries have followed judicial interpretation. 23 other countries have passed laws following judicial interpretation. And the other part of the argument is of striking down, which is that the notice regime. So one part is complete interpretation, no legislation. The second is striking down an existing legislation. Namely, those parts, what we call sections 5 to 9, where you are actually inviting disaster. You are there invading privacy. You see, you cannot require your privacy till you are married. After marriage, you perhaps require certain declarations and open. But before marriage, how can I invade your privacy and say that before marriage, you, madam, should declare your intent to marry X, keep that intent in a public declaration for 1 month, invite objections to it. This is a
Hmm.
complete invasion of your private space. So
So
these
you are
are legal arguments. I'm giving you a flavor only to tell you that how shallow and superficial is this objection that you're doing legislation. It's only to avoid, to delay, to prolong, to put in cold storage.
when the government makes the argument that a bunch of affiliated laws would have to change, even if you manage to legalize same-sex marriage by just reading spouse into man or woman in the Special Marriage Act, laws on domestic violence, dowry, rape, adoption, surrogacy, these would all have to change. That's one argument made by the center. The other is that now you get on board the opinion of all of the states, issue notices to all of the state governments, make them party to this argument. What do you say to that?
The second one is an example in the same line of further desperation. I think the Honorable Chief Justice answered it well because, as a last desperate measure, it was suggested that you adjourn the matter and call every state. Because what? What is the reason, Barkha? Because they may want to or be entitled to pass laws. First of all, if you are entitled to pass laws, you have to take the permission of the court. Tomorrow, suppose a law has to be passed. Do you need a permission of the court? Neither center needs nor state needs. Second, the Chief Justice responded to that interjection and objection by saying, oh, very good. Right now, under our nose, you have issued notice. You, the central government, have written to all the states. So, very good. Now they know about it, even directly. Otherwise, everybody knows about it through the press. And they are welcome to come and make their submissions. Tomorrow, if you pass a law, suppose you are state X, Barkha, you pass a law, it will be tested on Article 14, 15, 16. So, it's a fake objection. The first objection that what was the first point you said? You said something
That
else
you'd have to
before.
change other laws. That you'd have to
The
change.
other laws. Now, that is 90% wrong. For the
Why?
10% where it arises, those things have been kept aside by the court. For example, rape is a genuine issue. Of course, it's not such a big issue because conceptually, some criminal offenses conceptually are capable only biologically in a heterosexual. However, with one caveat, even in non heterosexual relationships, penetrative definitions of rape would apply. So, in that case, the court may take a call later on. They don't have to bring it down. They can say it's criminal law. We'll await. They can specifically make an exclusion that our holding of marriage will not be that rape also this holding will apply. One sentence will take care of it. But 90% of the other examples not told to you, Barkha, are normal irritants of daily life. Why should you not read person and spouse in place of male or female for your insurance policy?
Hmm.
Why should you not read person and person or spouse or whatever word you want to see equivalent, what is known as a gender neutral word, for a tenancy agreement, for a group housing? These are we have given in my note, there's an appendix 3, which gives 20 such examples. There's a third category. Why should adoption not be there? You tell me one good reason why you can't read same person or spouse there. A very remarkable argument, I mean, an unbelievable argument I heard from the government side, that if you and another person of the same sex adopt a child, that child's life will be destroyed because both the parents are the same sex. I mean, there is no end to the kind of. So let me tell you, if you dig deep, you see my appendix. 90% of those cases, examples I've given, would be covered by the spouse or person definition. Where, of course, you have a few cases. Section 27 is an exceptional example. You can take care of it. The court can say our ruling specifically doesn't apply to 27, which is rape. Rape in 99% cases is a heterosexual offense. It can be a penetrative
I mean,
non-heterosexual.
men have been raped by other men. Boys have been sexually assaulted by men. So, I mean, actually, it's gendered to the extent that the victim
therefore,
can be a
you are
man or a
right.
woman, but the perpetrator will always be a
The
man.
question is, Barkha, is it good enough ground to
Of course
jettison
not.
the baby
Of
with
course
the
not.
bathwater? There
Of
will be
course
some
not.
problems, but you throw the baby out
Of
is the
course.
argument because you have this one example of 27. That's the argument.
Yeah. Yeah. Here's my last question on this subject. What did you make of the Chief Justice wading into, in fact, a global conversation that's taking place on the distinction between sex and gender? You're born with a sex, but you choose your gender. Chief Justice Chandrachud says your genitals alone do not define what your gender is.
I,
How
I
did you
am
see this
proud.
conversation?
I am proud of a bench forthright and bold enough to articulate. But let me tell you, I started this argument, and the
Hmm.
Honorable Chief Justice spoke in that context. One of my arguments was that today you have to realize that gender and sex are not binary absolutes. Let me explain this. I started the argument with this, the 10 minutes when he asked us to give an overview, a summary on 18th of April. This was my
Yeah.
only argument. What does LGBTQ stand for? Do you know, Barkha? The entire acronym. I studied that after I went into this case. L
Yeah.
for lesbian, G for gay, B for bisexual, T for transsexual, Q for queer. Then comes I, and then comes plus plus. I is intersex. So there is a spectrum. It is a line with different shades and hues. It is not a binary male male on this end, female female on that end. In between are categories what are called intersex II. Intersex will include those who have partial or complicated organs. They don't have fully formed organs of only one sex. They, of course, include already those who are born in a body of a man but think more like a woman, and of course, vice versa. They are born in a whole shade of intersex persons. Now, you cannot have this judgment that I today hold that man, man, and woman, woman it applies to, and tomorrow you have to come to court once for so-called, persons with trans man with more of a woman with more of man leanings. Then you have a third petition coming after 6 months, trans woman, more of a man with woman feeling coming. This is not the idea of making this litigation piecemeal. It is, you are not, the point I made was either your lordship will reject our contention, you will hold that this is wrong. But if you hold that there is a marriage possible between same sex persons, then don't give a result which is hollow. Left hand gives you a concept, but marriage is not a label which Barkha Dutt will put on his hair or I'll put here and carry. Marriage meaning has to be what? Meaning has to be what is the content. Can it allow adoption? Can it allow insurance? Does it need a trans woman to come again for the same action exactly, but say now I'll argue the trans woman? So either you must conceptually deny the marriage part. If you give it, then these are automatic consequential things where in the narrowest of narrow class there is a problem, like the rape example you gave, and there are one or two more examples I concede. You just keep them aside.
And the reason that you're not touching personal laws is that you then avoid the entire larger debate over uniform civil code vis-a-vis, the group of religious leaders who have opposed same-sex legislation.
Well, let me tell you, in personal law, there are two categories. One is statutory personal law,
Yeah.
one is non statutory. Now, there is a lot to be said, and there is one whole batch of petitions apart from mine, which raises the statutory personal law issue, which you might hear on Monday or Tuesday when the matter starts, of the Hindu Marriage Act.
Yeah.
There, the challenge becomes a little more acute because the reading in, which we just talked about, spouse, spouse, person, person, may be more because the Saptapadi, the rituals, for in the non-statutory personal law, Muslim or others, it may be even more. My point was in the court, and the collectivity of our side point was, and the court has accepted it prima facie at the moment as we speak, is that you there is no need to reject something now. There is no need to definitively pronounce on something now. But always in a evolving dynamic situation, what is the need of forcing you to bite off more than you can chew and either decide the whole now or decide nothing? That's the argument of the respondent. If you cannot decide the whole, don't decide anything. Why can't you decide a special marriage act? Why can't you decide the gradations of LGBTQI, double S, double plus? The argument is no, unless you can't do a personal law also. But the court has said we are keeping it open in an appropriate case later.
Well, I have the optimism that we're standing on the cusp of history, but let's see what happens in the court. I want to take you back to another big high profile case that you were hopeful of, that you were disappointed in. The court rejected your attempts to build what you called a legal coalition on the issue of what you've alleged to be the misuse of investigative agencies against against the opposition parties. We know the data. There's a fourfold increase in the number of cases since 2014. More than 90% of these are against the opposition. You galvanized 14 parties who went to the Supreme Court. The Supreme Court did not entertain your petition. What do you do next?
Uh, I fully know the naysayers. I know fully the brickbat throwers, and I know fully the critics. No problem. Uh, According to us, there are significant gains of what you just mentioned. One, you got 14 parties together. It's an extraordinary achievement. Two, all the 14 parties, and I'm personally witness to that, understood the possibility of it not going forward. Three, it was based on these four propositions, which I'll save time by not repeating the statistics. Four, to these three propositions was married the concept of basic structure, a level playing field that you must have. And five was the guidelines for pre-arrest or if arrested, grant of bail. Now, the court actually heard us very respectfully with great dignity. It appreciated our point of view and then specifically allowed us to withdraw, a point our great critics and brickbatters like not to emphasize. They repeatedly said our doors are open, you come in an actual case. This is on the record. What they found something difficult to handle, which is why they did not entertain, is that there's no specific case. But along with that, there was one clear error by the court, which possibly we were not able to fully explain, or possibly whatever the court is entitled to. It allowed us to withdraw it. That was a supposition that we are seeking a special dispensation for public life persons. But what is missed out is that there are two sentences written preemptively in the petition itself, Barkha. Sentence number one, we don't want this petition to affect any pending cases. This is only prospective. Sentence number two is even more important. Although the catalysts for this are political parties who are the petitioners, relief, if given, will apply to everyone. It will not be limited to political parties. Now, unfortunately, the court saw the construct of the framework as one seeking a special position for political parties. But ultimately, they understood and they said that, look, we will rather deal with individual cases of public people rather than a collectivity. And that is how it was allowed to be withdrawn.
Okay, let's move on to the other big case that you argued, the Shiv Sena, who's the real Shiv Sena, Eknath Shinde, Uddhav Thackeray. That judgment is reserved. But as we wait for that verdict, there is persistent sort of speculation that one of your allies, Sharad Pawar, who's already broken ranks with the opposition on the Adani issue, for instance, and the JPC demand, could be shifting or in anticipation of the Supreme Court verdict, which could theoretically could disqualify 16 MLAs. How do you look at this joining the dots between the legal and the political developments?
You notice how ironical and interesting a comment you made just now. You put some political dots, which actually suggest a very optimistic, positive legal outcome.
Well,
It pre
obviously
it pre it no no
somebody
it
thinks
pre,
that those MLAs could be
it,
disqualified,
it,
right?
it, it presupposes
Yeah.
your underlying presupposition is an
Yes.
optimistic, positive legal outcome, from which follows a speculative political question. Now, anyway, that is just by the way. See, obviously, as far as the political party is concerned, neither you nor I can mention it. It is like the ever shifting sands of time. And there have been some very fast moving sands of time in Maharashtra earlier also.
Yes.
So, even between yesterday and today, when we are recording this program, I find diverse statements coming from Maharashtra. So, I don't think anybody can really guess. The official stand is what we can go by. The official stand from both parts of what might be called the NCP and including the Supremo of NCP is that all is well with it. So I think
Do you,
it's
be-
speculative.
do you believe the official? Do you believe
No,
Sharad Pawar?
no. Today, you see, Sharad Pawar is also, don't forget, the glue which is held together this Mahagathbandhan
Of
in
course,
adverse times. His
of course.
moral, moral force, wisdom, and maturity is sometimes very grossly underestimated because he has actually held it together. I don't think that he's flippant about it or that he's going to be very casual about such statements if he's made it. Obviously, only he and your interview with him can tell us the truth, not me.
Okay.
But certainly, I would not say it's a very casual statement. It's happened over 3 days and twice by him and twice by his nephew. So, I mean, I would rather like to go by their official version. But let me turn to the other part. Do you know, Barkha, that there are only two things which are the issue there? One is very strongly made out, and we are nobody to interpret or anticipate the judgment. We are not here to be presumptuous about Supreme Court. It is it is bound to come within next 3 weeks because one of the learned judges is retiring, so we don't have much time to wait now. But do you know that the governor's action in doing what he did, at least in our understanding and contention by documents we produced to you in the court, show that there was no basis. So the worst, now I'm giving you the worst scenario, if the court does not disqualify and it holds declaratory wise that the governor's action is bad, that's a big slap in the face of this dispensation which allowed this to happen. Number two, there is no doubt that that the disqualification also should logically follow. Now you may hold it not to happen in law because time has elapsed, because the floor test is, voting on the floor has happened. But those are technical points. I think we have a strong case, and irrespective of the political, hullabaloo going on, I think there is something to be optimistic and hopeful about on the legal side. And
Well,
if you are right, then it presupposes an optimistic legal result.
all right, we'll wait for that one. Before we let you go, I do have a question that concerns the larger debate around the collegium, and in particular around a judge who's one of the most respected judges in the legal fraternity. I'm talking, of course, about Justice Muralidhar. Now, we saw the collegium withdrawing its recommendation for the for Justice Muralidhar becoming the Chief Justice of the Madras High Court, because the file that suggested this is sitting with the government. The government hasn't moved on it, and Justice Muralidhar is about to retire in a few months. This comes against the backdrop of a growing confrontation between the government and the collegium over who should appoint judges. How do you see this withdrawal of the recommendation? Instead of withdrawing, shouldn't the collegium have been more assertive?
Barkha, let me summarize my answer because we're running out of time in 3 or 4 sentences. Number one, the awareness and acknowledgement that Justice Muralidhar is one of the really outstanding judges in the entire community of 1100 High Court judges and Supreme Court judges is undeniable. I mean, I have no hesitation in saying it. I don't normally say it by name for everybody, but since you're talking of a name, outstanding is the word, not good, not very good. Number two, the collegium has taken it upon itself, is wrongly being blamed. The collegium has done the right thing.
Okay.
The blame lies squarely with the central government, which is blatantly, brazenly, and egregiously punishing a independent judge who dares to speak his mind, frequently in favor of the government, sometimes against, but this government appears to see only the against. Number three, the collegium took a wise decision for the simple reason that they know the power of delay in the government. The government has sat on Justice Muralidhar's transfer. Indeed, it sat on his elevation as Chief Justice earlier for months. Transfer is something you don't take more than 2 days. Transfer, you don't even wait. There's nothing in a transfer. It's the same position as Chief Justice from one to another High Court. Look at the cussedness of this government. Now, the collegium realized that this very unfortunate and deserving judge would be retiring in August. And if they kept on pressing, they would achieve nothing.
Why
So,
not? Why not? The final say is meant to be that of the collegium. The collegium
yeah,
could
but
have been
you
more
just run out
assertive.
of time. You run out of time. You keep him under a cloud and a controversy. So, it is much better to confirm him in the position he is. And by the way, by nature, Justice Muralidhar is a person who doesn't care. If you post him anywhere, he'll do good work there, and he's not really after post. But that's apart. So they did the right thing. That in the time left, give him full respect and dignity. And ultimately, what would he would have only got 2 months, right? In Madras, 3 months. So that would be tokenism. The real fault is of those who have delayed it. That should be castigated. It should be condemned. It is a direct onslaught on the independence of judges. Forget Justice Muralidhar. He will go away in August. The point is, you are showing that you have the power of delay. And my suggestion more than 10, 15 years ago, I've written articles on this is just once on your reiterated second time recommendation, if the government doesn't act, just once issue a contempt notice to at least the law secretary, if not the law minister. This will all stop. Sermonizing will not stop it. Your
So you think
expectation and hope will not stay with.
you think the collegium could have done that instead of recalling its
Not
proposal?
collegium, the court. The court is entitled to do that. And it will happen in the near future. I'm telling you, if this goes on like this. See, the law is very clear. If I recommend Dutt once, she can be returned. If I recommend Barkha Dutt the second time, she has to be appointed. If you don't appoint after 15 days, why can't you issue notice of contempt? That's the law of the land by 3 9-judge judgments.
Do you
5-judge
believe
judgments,
so do you believe the court should issue contempt notice to the law secretary on the Justice Mullidhar case? Now it
I
can't
believe
because now it can't.
as I said, let's not embarrass Justice Muralidhar or waste time on that because he has got a dignified place. But I've said it generally for many more cases which happened earlier. We know the names. You and I know the names of the previous cases. The moment, see what is happening is three things. It's very serious, Barkha. I'll take 30 seconds. One, a delay in your elevation from the bar to the bench at the High Court level destroys your career. You know, you are elevated, you are going to be made because you are very good. 1 year is taken. In the meanwhile, I and 5 others we are senior to you. They will make you with great grace and fanfare after 1 year. Second, once you are there and you are elevated to the Supreme Court, recommended for elevation, you again do the same thing, you delay. There are 3 examples of the Supreme Court of today, 3 or 4, where this has happened. You deny them Chief Justices ships. Third, you do it the same for transfer. Initially, you are appointed to a smaller or a medium-sized High Court. You are very good and you are promoted. I mean, you are transferred to a bigger High Court. You take it. Do you know what has just happened in Himachal?
No, tell me the Himachal
The,
case. I
la-
don't know.
the lady there was acting Chief Justice, and she had only to be notionally paper confirmed as Chief Justice. She was recommended for Chief Justice in the court where she is already sitting as acting Chief Justice. They did not do it till the last day. She retired 2 days ago. So you retired as acting Chief Justice. What is the implication? A Chief Justice of a High Court gets the perks and the pension of a Supreme Court retired judge.
Right.
Look at the cussedness. You're not sending her anywhere. She's only going to be confirmed in her own place. And the collegium has recommended that you should be confirmed as Chief Justice in Himachal. Now it's true that her daughter is accused of a murder charge. But there's never been an allegation of any complicity of that judge.
Well, the Justice Mullidhar case certainly has no such controversy attached to it, and therefore it's an even more startling development. Abhishek Singhvi, always a pleasure. We could go on endlessly, but time is short. Thank you so much for your time and a lot of these big cases that are going to unfold in the days to come. Thank you very much, Abhishek. Take care. Take care.
We started Mojo right here in this basement. Just 4 people, 4. And now we're about to hit our first 1 million subscribers. So this is to say thank you to all of you for your support, for your respect, and for your encouragement. We've always gone to where the story is. During the pandemic, when television's big anchors were hunkered down in their studios or at their homes, we hit the road. We traveled from Delhi to Kerala, covering 30,000 kilometers in a small car, reporting from inside ICUs and inside slum tenements. Whether it's flash floods or war zones, we've always put our boots on the ground. In fact, we're just back from Punjab, tailing the Khalistani fugitive Amritpal Singh. And through all of this, we have always put you, the people, first. In an age of partisan polarized media where most journalists are either chamcha ya morcha, we believe the story is sacred and the truth of the story is what matters. And now as we get ready for the next step, we need your help. Become a Mojo member and get first access to all our big interviews. Get a chance to ask our newsmakers questions. Get a chance to write and report for us for both our website and our channels. And also, interact with me and my colleagues directly through AMA sessions. Literally, ask me anything. Click on the join now right next to the subscribe button, and yes, also subscribe if you haven't yet, and become a Mojo member for just 159 rupees a month. Hope to see lots of you in our community.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.